then when we interpret the United States Constitution, why do we let lawyers do it? Why don't we just hire history professors?
The history that judges are looking to in interpreting the Constitution and other statutes is primarily legal history.
Aren't you tempted to go look at the history just to make sure that your interpretation is correct?
It depends, I suppose, on the particular statute and the nature of the history at issue and the question.
But don't you want to just go take a peek?
Senator John Kennedy just did what very few politicians in Washington have the backbone to do anymore. He exposed the legal games the elites play when it comes to interpreting our laws and even our Constitution. And I've got to say, the exchange we just watched wasn't just a boring legal debate. It was a masterclass in showing how far the legal establishment has drifted from the original intent of this country. This is the Prodigy Unfiltered.
Senator Kennedy's the next. Senator Kennedy, you're the next one.
Thank you, Mr. Chairman. Counselor, as you know, it's hard to pass a bill in the United States Senate. Our founders intended that to be the case, and consequently, if a bill does pass, it's gone through a long, arduous process. A lot of reports issued, a lot of debate, and all of it's written down. Why has it become common practice, and do you support it, of ignoring that rich legislative history when you interpret a statute?
Well, Senator, I think the first rule of statutory interpretation is that the text is what's paramount. And that's because the text is what actually proceeded through bicameralism and presentment, which are really just the fancy.
Of course, it's paramount, but why can't the text be supplemented by looking at the history?
I think the legislative history can sometimes provide a tool to help interpret the text. And it's often in parties' briefs, and I would, of course, consider it that way. But it's just important to keep in mind its subordinated role in that interpretation, because the intention of any particular legislator does not have the force of law. Instead, the text does. So the legislative history and the intentions of specific legislators should never take primacy over the text or refute the text.
But it doesn't have to, does it, Counselor? It just gives you context.
I agree with that.
When you interpret a statute or write a brief, and you think that the language is plain, aren't you tempted to go look at the history just to make sure that your interpretation is correct?
It depends, I suppose, on the particular statute and the nature of the history at issue and the question.
But don't you want to just go take a peek? You look at the language and you say, well, this is as clear as thunder on a summer night. But maybe I'll just take a peek at the legislative history to make sure that I'm not out in left field. And the Supreme Court condemns that, does it not?
The Supreme Court does not uniformly condemn that, and there are certainly cases where, you know, legislative history or statutory history has provided a tool.
Sure they do. I mean, originalism, and I'm not saying they're wrong. Please don't misunderstand me. I'm just trying to understand your perspective. Originalism and textualism is accepted even by the left of center justices. And I've read opinion after opinion, lower courts as well, where they say, well, legislative history, we can't rely on it.
Legislative history cannot be relied upon to trump the language of a statute. And so when the language of a statute really is that clear, Senator, there's not that much, and it bears directly on the question before the court.
Well, let me ask you something. Does the Supreme Court sanction looking to the Federalist Papers and interpreting the Constitution?
Yes.
Why isn't that legislative history?
The process for ratifying the Constitution is, of course, different than the bicameralism and presentment process that applies to statutory text. The Constitution was, of course, publicly ratified.
No, it's not.
Well,
you look at the plain language, don't you?
Yes. But in looking at the plain language, the question we ask is, what was the original public meaning of that language? And in the case of the Constitution, the original public meaning is elucidated by the debates surrounding its ratification. And those debates are really captured in the Federalist Papers, the Anti-Federalist Papers, the ratification debates, the notes from the Constitutional Convention, documents like that. So those documents can bear directly on the constitutional text in a way that is more legitimate necessarily than the, statement of an individual legislator would be vis-a-vis a statute.
Well, then when we interpret the United States Constitution, and I agree with you, that's the case. I'm just asking you whether you think it ought to be the case. Then when we interpret the United States Constitution, why do we let lawyers do it? Why don't we just hire history professors?
The history that judges are looking to in interpreting the Constitution and other statutes is primarily legal history. It's not something like, a biography of George Washington. It's instead things like statutes or, debates about statutes, the Federalist Papers. And certainly, I think law schools could do a better job and should do a better job, teaching students how to read that legal history. But it is fundamentally legal history. And then the task the judges have in reading that legal history is to draw analogies between that legal history and our modern times. And that analogical reasoning is, I think, a fundamentally lawyerly task the judges are particularly skilled at.
Thank you, Mr. Chairman.
Let me lay this out plain. Kennedy was asking a simple, honest question. Why do judges and lawyers today keep ignoring the legislative history behind the laws Congress passes? Our founders made it deliberately hard to pass a law. They wanted debate. They wanted compromise. They wanted every word fought over and carefully chosen. And yet, when that bill finally becomes law after months or even years of public discussion, the courts often toss all that aside and say, well, the text says this and only this. Now don't get me wrong, the text is important. Of course it is. But Kennedy was making a deeper point here. Context matters. If a law is the result of hours of hearings, mountains of reports, public testimony, and debate, why the hell would we ignore all that? Why would we strip the law of its historical meaning and just treat it like some isolated sentence floating in a vacuum? What you're hearing from the nominee is the modern legal elite's obsession with textualism, the idea that only the words on the page matter. And listen, textualism has its place. We don't want activist judges inventing new meanings out of thin air. But Kennedy is right, there's a danger here too. Because when judges refuse to even look at the history, they end up bending the text to their own interpretation, and that's just as dangerous. And here's where I'm going to say something a lot of people won't. This is exactly how unelected judges and bureaucrats end up running the country instead of we the people. They hide behind textualism or originalism, but too often it's just a cover for cherry-picking the meaning they want. They ignore the debate that actually happened in Congress, the debate our elected representatives had, and replace it with their own view of what the text should mean. That's not law. That's judicial activism in disguise. Kennedy's peak analogy was perfect. If the text seems clear as thunder, why not check the history to make sure you're not missing something? That's called due diligence. But these legal elites act like even peeking at legislative history is taboo.
And why?
Because if they looked at it, they have to confront the actual intent of the lawmakers, and sometimes that intent doesn't line up with the agenda the courts want to push. And then Kennedy hits them with the Federalist Papers example, and man, that was a checkmate moment. The Supreme Court loves quoting the Federalist Papers when interpreting the Constitution. They call it original public meaning. But guess what? That's history. That's literally the debates and writings of the people who wrote and ratified the Constitution. And we treat it as gospel. So why is it okay to use history for the Constitution, but not for statutes? The nominee tried to dance around it by saying the Constitution was publicly ratified, but that doesn't erase the fact that context still matters. Here's the deeper truth, folks. The reason they don't want to use legislative history is because it holds them accountable. It ties them to what Congress actually intended, not what some judge decades later wants the law to mean. That's why the left hates it, because if judges have to follow the original intent, they can't twist the law to fit their progressive social engineering. And sadly, too many so-called conservative judges have gotten comfortable playing the same game. Kennedy's final question nailed it. If interpreting the Constitution is just about understanding history, then why not hire history professors instead of judges? And the nominee's answer said it all. He admitted that judges are really doing analogical reasoning, drawing lines from the past to modern issues. And you know what that means? They're making judgment calls. And if they're going to make judgment calls that affect every American's life, then they damn well better be anchored to the will of the people, not their own ideology. I want to hear from you. Do you think courts should look at legislative history when interpreting laws, or should they stick strictly to the text? Drop your thoughts in the comments below. And if you're sick of watching elites twist our laws while ignoring the people who wrote them, make sure you smash that like button and subscribe, because we're going to keep calling this stuff out. This is Prodigy Unfiltered. Like, share, subscribe, and stay in the fight. God bless America.